Good afternoon and a warm welcome to everyone, and thank you for joining us today for our TDS webinar, Student Rentals Made Simple, a Landlord's Guide to Managing Student Tenancies. Allow me to introduce myself. My name is Ellie Tompkins and I'll be your host today. Sandy Baston and Sanam Khan from TDS will be delivering today's session. Feel free to ask questions in today's webinar. Please use the questions icon on your webinar dashboard, and we will review all the questions at the end of the presentation and do our best to answer as many as possible. Our webinar platform also allows you to make notes. Look out for the icon which shows a piece of paper with a pencil on top. In the unfortunate event that you do experience any internet or connectivity issues, please try to refresh your web page in the first instance. If for any reason this doesn't work, please close the webinar in your internet browser completely and click back on your webinar reminder email, and hopefully this will solve any issues that you may have. I'll now hand over to Sandy to introduce herself and deliver the first part of our session today.
Thank you very much, Ellie. So Sanam and I welcome you to the webinar today, Student Rentals Made Simple. So we're going to have a quick look at a landlord's guide to managing student tenancies. Firstly, though, just a brief rundown of what it is that TDS does. So Tenancy Deposit Scheme is the UK's longest running government-approved tenancy deposit protection scheme. So we protect deposits, enable you to comply with the legislation under the Housing Act. So you're able to do so under our insured scheme, where there is a low fee and you hold the deposit, or our custodial scheme, which is free to use, where the deposit is paid over to TDS and we will hold it throughout the duration of the tenancy. The legislation also says that not only must we enable you to comply with the legislation, but we must also provide a free alternative dispute resolution service at the end of the tenancy in the event that you are unable to reach agreement between yourselves as to how the deposit should be distributed. We have heaps of guidance, free resources, guides, tools and webinars such as this one that you're attending today to help both landlords, agents and tenants. So compliance, how do you protect them? As I've mentioned, you can do that via our TDS insured scheme or our TDS custodial scheme. So any agent landlord taking a deposit from a tenant on an assured short hold tenancy must safeguard it in an approved scheme. And the statutory deadline for you to do this is 30 calendar days from the date the deposit is taken. So receipt of the deposit. Not only must you register and protect the deposit, you must also serve relevant prescribed information. So tenants and a relevant person, and that is anybody that is paying a deposit for and on behalf of the tenant, must be told which scheme protects the deposit and be served prescribed information. And also a scheme leaflet. It's important to note that early service of prescribed information will be non-compliant. So you must not serve the prescribed information and the scheme leaflet before you receive the deposit. TDS will also provide a tenancy deposit protection certificate for you once you have complied. So what happens if you get it wrong? So under Section 215 of the Housing Act, there are statutory penalties for failure to protect and failure to serve prescribed information. So effectively, for both, the tenant or the person who paid the deposit, so that is the relevant person also, can take the landlord or agent to court. And the court can order the landlord or agent to protect the deposit or repay it to the tenant. And then, importantly, the court can also order compensation to be paid to the tenant between 1 and 3 times the deposit's value. And certainly in relation to no protection, then any Section 21 notice, whilst we still have them, will be invalid until such time as the deposit has been repaid or after any court case about the deposit has ended. So as you see, this also relates to the relevant person. So the relevant person might not be named on the tenancy agreement, but they can take action for failure to protect or serve prescribed information, even though they're not on the tenancy agreement and after the tenancy has ended. I thought it might be useful just to have a quick reminder of the Tenant Fees Act that came into force some time ago now on the 1st of June 2019. Slightly different legislation in the jurisdictions, so England and Wales are slightly different. But obviously holding deposits are capped at 1 week's rent, and there's certain criteria for them to be refundable. And the security deposit is capped at 5 weeks' rent in England, 6 weeks if the deposit is over, the rental is over £50,000 per annum. It's no longer possible to take a pet deposit. So if you have already taken the 5-week maximum, then you will not be able to take any further monies towards a pet deposit. We do have a deposit calculator on our platform, website. So do please visit depositcap.com to find out more on that in that respect. So not only does the Tenant Fees Act sort of limit the amount of deposit that you can take, it also sets out prohibited fees and permitted fees. So there are very few permitted fees, and a lot of what perhaps you were used to be able to take from or claim from a tenant's deposit are now prohibited. So we have a really good tenant fees ban matrix on our website, so please do take a look at that. And it sort of splits it between England and Wales and lets you know what's permitted with the tick and what you're no longer able to claim from a tenant's deposit. A really useful ready reference there for you. Sorry, let me just move on to the next slide. I think that's just a bit of a, yeah. So just going back to sort of legislation. So obviously I've mentioned the Tenant Fees Act, and I have made reference to the Section 21 notice, and that obviously is currently still available. But we do have the Renters' Rights Bill, which replaces the Renters' Reform Bill, and we expect, I think, royal assent in the autumn. The commencement date is unknown, but just a very, very high level overview for you. Obviously, it will abolish fixed terms. The short hold tenancies will convert to periodic assured tenancies. There's 2 months' notice to vacate. So that's a tenant can give 2 months' notice to vacate. So from a sort of a student landlord perspective, there's no certainty as to how long students will remain in the property. Rent in advance is not able to be taken, but they believe there's some recent amendments that may allow transition arrangements for existing tenancies. Section 13 statutory process for rent increase as opposed to a clause within the tenancy agreement. So you will require rent to be increased under the statutory process, and it will 2 months' notice will need to be given to increase rent expiring on the rent repayment day. A tenant will be able to challenge via the first tier tribunal, and I believe that recent proposed amendments might allow a regulation to be coming in at a later date, which will allow the rent increase to be backdated as opposed to it taking effect once the first tier tribunal has actually reached an outcome. Obviously, purpose-built student accommodation falls outside the Renters' Rights Bill, and much later on we will be having the Decent Home Standard. Awab's law will be extending to the private rented sector. It is obviously already in social housing, and then we will be looking forward to a single ombudsman, landlord licensing, and a landlord database. There will also be local authority powers to enter properties, and bidding wars will be abolished. So I appreciate that's a very high level overview. However, we will be able to provide guidance and webinars on that going forward as and when the bill receives royal assent. It is unlikely, we think, to be in the before the recess on July the 22nd or the 26th, I think, but we will obviously be providing guidance on that in due course. So looking now at student rentals generally, the definition of an HMO is a property that's rented out to multiple unrelated households sharing amenities. For example, shared houses, flats, bedsits, or converted buildings. So the key characteristics of an HMO, it must be for residential use, so not commercial spaces. There's a minimum number of residents. So a property is typically classified as an HMO when it has 3 or more residents, and they must be from more than one household. So the residents, where the residents are not all from the same family or a single household. The residents must share amenities, so such as bathrooms, WCs, kitchens, and the rent payable is typically paid for the accommodation, even if it's provided instead of wages. So that's your definition of an HMO, house of multiple occupation. So sort of the legal requirements, licensing. So many HMOs require a mandatory license from the local council, especially if there are 5 or more tenants, and your HMO must have had a written risk assessment. It's really key to make sure that any insurance you have covers public liability, property damage, and loss of rent. And you will, of course, need to carry out right to rent checks. So landlords in England are legally required to check that tenants have the right to rent in the UK. There are minimum room sizes that are enforced by the local authorities for sleeping. And so, for example, rooms used by one adult must generally be at least 6.5 square metres, and for 2 adults, 10.22 square metres. HMOs must have adequate fire precautions, including interlinked smoke alarms, fire doors, and clear escape routes. And in relation to council tax, the tenant is responsible. If all of the tenants or the household is entirely made up of students, then the property will be exempt from council tax. So that's key to remember there. If there are 4 students and 1 that isn't, then there will be council tax liabilities that will arise. Obviously, as with any sort of rented property, a gas safety certificate is required annually also. But if you do have any doubt as to what is required in your particular area, then please do contact your local authority for some assistance. So some standard tips. Property management. HMO landlords must ensure repairs and cleanliness of the communal areas. It's really key to maintain the property and carry out regular inspections, and any repairs that are reported to you to be remedied promptly. And upgrades can prevent issues and will also attract tenants going forward. You should prioritise safety and security, so good exterior lighting, secure doors and windows, and perhaps a security system might also prevent any damage and may also attract tenants too. You may want to consider all-inclusive rent, so including utilities in the rent simplifies budgeting for students and can be a significant draw. You may obviously want to furnish for durability, so opt for robust, low-maintenance furniture that can withstand student life. Providing study spaces, I think, is something also that you might want to consider, offering desks and chairs in bedrooms or a dedicated study area. And also a reliable internet is not just key for students. I think it's key for everyone these days, particularly people who are working remotely. So high-speed internet is a must-have for students, particularly if they have online lectures. So how can you sort of reduce deposit disputes in student accommodation? I think it's probably really useful to carry out reference checks. So before signing a tenancy agreement, make sure that you've perhaps got a reference for the tenant or tenants on all of them, or request a reference from the university or previous student housing provider. it's really key, and we'll run through this a little bit later, to have a very well-written drafted tenancy agreement that contains all of the right clauses to enable you to make deductions from the deposit at the end of the tenancy, and that is the deposit use clause. You may want to have a parent or another adult family member to serve as guarantor in the event of breaches of obligations, particularly in relation to paying rent. And this will ensure that if there are any rent arrears, that they are repaid even if the student is unable to do so themselves. Obligations. So these are the tenancy obligations, which we'll come into a little bit more detail. Give clear directions as to what is required of the tenant, so that they know there is no doubt about what is and what is not allowed in the property that is being rented to them. And a move-in pack is really useful, that describes where things are, how to use appliances. It will contain the inventory, how to avoid causing damage, where to report issues, things like that is really useful as well. And that can reduce disputes either mid-tenancy or at the end of the tenancy as well. So I've mentioned the welcome pack, but which should include the check-in and inventory. So you need to provide tenants with an opportunity to review this document and ensure all tenants sign the inventory at check-in. If you're unable to get a signature, then I think it would be really useful to have a good audit trail that they have actually been sent the document. Communication is key, so at all times keep open the channel of communication, and you may find that you need to give more pointers and provide more assistance than you would with seasoned tenants, particularly if it's students that have just left home for the first time and they're living on their own for the first time. Carry out regular inspections, sort of midterm tenancy inspections, and write them into your tenancy agreement so that you have the tenant is aware when you'll be doing them, obviously giving sufficient notice, and how frequently you will be doing them. And then also at the end of the tenancy, a really good thing to do is to remind tenants to review the check-in report at the start of the tenancy so that they can make sure that they return the property to the same standard, condition and cleanliness as it was at the start. So I'm just going to hand over now to Sanam, who's going to talk a little bit about T-Life. Okay. I think there might be a slight problem with Sanam she's having tech issues. So what I will do is I will carry on. So you may find that any student tenants that you perhaps are considering renting to will show you a T-Life app. And this app is something that we have partnered with OpenBricks to enable tenants to become rent ready. So they will have effectively carried out a lot of the checks that you would need to do yourself themselves. So they would be able to demonstrate to you affordability. They would be able to provide evidence of their right to rent in the UK. They would have verified their ID, and they might, in some cases, have fully referenced themselves, and they may be able to provide also a previous rent payment history. And once they've got all of that information together, then as and when they find a property to rent, then they are able to share that information with you as landlord, and then you would be able to make a decision on that basis. And I think it goes to show that a tenant that goes to this level of trouble to secure a potential rental property shows that they mean business and that they understand their obligations and what's required of them. But it's certainly just to draw it to your attention that this T-Life app is available to tenants to rent smarter, get themselves ready, particularly if there are lots of students perhaps going for a particular property. that does quite a lot of the work for you. I believe that there are in use probably, I think there's 200,000 tenants that are using this app, T-Life. So we just thought it would be really useful to bring it to your attention so that when you see it, you will understand what it is if you do see it. The other thing to be aware of is the tenancy redress service. So you've got your tenants in place, and perhaps there's some issues that arise mid-tenancy. So a lot of people would consider or think of TDS as an end of tenancy dispute resolution service provider. But actually we do offer mid-term tenancy service as well. So this is free to use. You do not have to be registered with TDS, and you can agent landlords or tenants can come to the tenancy redress service, and we will be able to deal with a large variety of complaints where the relationship between the landlord and the tenant has severely broken down. So we can look at poor property standards. So, for example, you have asked the tenant to carry out some repairs or to stop doing something, and the remedial damage is becoming worse, and they're just not listening to you. Similarly, a student tenant may very well report an issue and want it to be repaired, and it's not being done. So reciprocal. So including the disrepairs. A tenant might think that a landlord is perhaps coming into a property unreasonably. Obviously, the tenancy agreement should allow a tenant to have quiet enjoyment, and perhaps too many inspections are being undertaken. So we are able to consider mediating between the landlord and the tenant, or if you're a landlord that instructs an agent, then the agent can attend on behalf of you as landlord. And we will look at trying to mediate between the items that the areas of sort of dispute that I've discussed, to include rent arrears and also very low level noise or antisocial behaviour. It's key to remember that the redress service requires the consent of both parties. So we will do what we can to, get the other party to attend the mediation. And we have been very, very successful in the ones that we've had. So do take a look at our website, tenancyredress.com, and you will see some testimonials there as well. Just be clear, though, that we're not, the service is not there to help you evict a student tenant or deal with serious antisocial activity or deal with end of tenancy deposit disputes. So that is the different service, which is tenancy deposit scheme. And obviously the tenancy redress service, our mediators are unable to provide any legal advice, but just where the relationship is severely broken down, you want to sustain the tenancy, but you just need a little bit of help in that communication. So the resolution offerings that we have. So our goal, the primary goal of TDS, is to facilitate mutual agreements between parties with adjudication actually considered as a last resort. We're here if you need us to make a formal adjudication decision. But we would very much like to resolve these disputes much sooner than going all the way through to the adjudicator. And there's a number of reasons for this. Obviously, we would like tenants to get any portion of their deposit back that they're entitled to move forward onto their next rental. Deposits, are quite large, and so to have to try and find another large deposit whilst one is already sort of tied up in a dispute process is it can be quite difficult for some. And also, if there are issues that have occurred during the tenancy, such as damage, then we would like the landlord to have some of that deposit that they have been able to show with evidence that they are entitled to in order to carry out the remedial repairs as quickly as possible so that they can then move on, carry out those works and then get the property re-let. So we do absolutely consider that even if you come to adjudication, that negotiation, you must have at least shown that you've tried to negotiate yourselves. And that is a requirement under our scheme rules in the event that you actually do have to go all the way to adjudication. So you do need to engage in the process. And we employ two methods of resolution prior to the end of tenancy adjudication to aid in you reaching agreement. And the two methods that we use are self-resolution and early resolution. So touching first on self-resolution. So the platform that we have, once you've protected your deposit and you need to release it, either via our custodial scheme, via a repayment request, or if it's an insured deposit, then a deposit allocation proposal. The platform allows landlords, agents and tenants to come to an agreement without the need to move to formal adjudication. So at the self-resolution stage, you can make proposals on the deductions. You can let the tenant know what it is that you're wanting to deduct. And then they can respond directly on the platform. You will be notified when they respond, and the parties can negotiate between themselves. You can track your case's progress and settle your own disputes promptly. So in 23-24, a total of 35.6% of all disputes that came to TDS were resolved either via self-resolution, but the parties doing it themselves, or by early resolution, which I'll come on to next. The benefits of self-resolution, we find that parties are very much happier with the ability to decide themselves how the deposit is distributed at the end of the tenancy, as opposed to having a formal adjudication decision thrust upon them. So wherever possible, we try and encourage parties to negotiate themselves. And a little bit later on in the webinar, we'll look at the factors that you need to take into account to ensure that when you are starting those negotiations, that you are proposing something that's fair and reasonable. And if it's fair and reasonable, you're more likely to get the agreement of the tenant. So that's self-resolution. So now let's have a quick look at early resolution. So let's say you've jumped onto our platform, you've tried to negotiate, perhaps some of the areas of claim have actually been agreed by the tenant, but some haven't, and you've reached some agreement, but not all. So anything that's agreed at the self-resolution stage will fall away, and anything that is left will go on to adjudication. But before it does go on to adjudication, you'll also have valuable opportunity for early resolution. And this is where our resolution team, at various stages of the process, they will explore perhaps mutual agreement possibilities before you go to full adjudication. And this is termed early resolution. And so we may reach out to one or both parties for additional information, extend perhaps some settlement offers, or facilitate further negotiations. And as I've said, this gives more control for the parties of the outcome. It allows more flexibility than a formal adjudication decision. And as I mentioned, it leads to greater satisfaction and the more quick distribution, prompt distribution of the deposit. I hasten to say, though, that we have very good time days in which we actually do produce adjudication decisions. We have to produce them within 28 calendar days after the evidence gathering process, and we're very much quicker than that. We're between 15 and 20, so it's not too long anyway. But anything that you can do to get monies back to carry out remedial works or for the tenants to move on, then we are in full support of. So the general disputes that we see are, as I'm sure you would, no surprise to you, 65% cleaning, 45% damage, redecoration 32%, rent arrears, and then gardening. And we do have an other claim also. And generally speaking, the trend year on year is that the disputes are initiated by majority tenants, so 76%. tenants, and the remaining are agent landlord proposals. So when you're negotiating to try and resolve early, do think about the dispute objectively. Also, it's really beneficial to provide clear and objective advice about any claim from the tenant's deposit. Fully utilise any self-resolution built-in negotiation platforms, as I've just mentioned, and do use a structured approach to your negotiation by justifying your cost. We find that a really structured approach actually sort of focuses the mind, and if it's just literally the detail, not what's gone on in the tenancy or how perhaps you may have been disappointed by something the tenant has done, or the tenant's disappointed what you've done, then just focus on the actual proposed deduction in a structured way, and that can lead to successfully concluded negotiations. And do support your deductions with evidence rather than just saying what the deductions are, because if they can see that there's evidence to support that deduction, and in the event that it's not agreed, then that evidence will be supplied to the adjudicator, then they are more likely to potentially agree also. And also, if the tenant is responding to your suggested deductions, as to rebutting them, then do take the time to fully consider those tenants' responses and double check any relevant or persuasive comments that the tenant may have. So I mentioned that we were going to talk a little bit about the tenancy agreement and check-in reports. So best practice to help you avoid disputes is really to prepare for the dispute at the start of the tenancy. And you really do need key documentation. So you need a decent tenancy agreement. You need to have a comprehensive signed inventory, but preferably with embedded photographs, which enables the adjudicator and the tenant to see the date on which those photographs were taken. And it's really key and essential to keep a written record of any agreements during the tenancy. So a tenant may say to you, the student desk has broken and it was in poor condition at the start, can I dispose of it? And you may say, yes, absolutely you can, but I'm not replacing it, or and so at the end of the tenancy, if there is no student desk, and then you claim for a missing desk, then obviously the tenant will be able to say, well, actually, I told you that it had broken. You said that I could dispose of it, and that's why it's not there. But you need to have a written record of anything that is agreed between you and a student during the tenancy. If they wish to paint a wall, or then you can perhaps say yes, because the tenancy agreement requires them to obtain consent, and you can perhaps set out conditions that it has to be returned to the same standard, to the same colour it was at the end of the tenancy. The reason that a good audit trail is really key is because if you do have to go to adjudication, then neither party can rely upon a statement alone. It is a documentary evidence-based process. So in the same way that you would need a really detailed check-in report, you need to have a checkout report, and also you need to provide and keep receipts and invoices. And that's not just receipts and invoices to support the costs that you're incurring to rectify any issues at the end of the tenancy, but it may be that those invoices and receipts will actually support your statement that an item was new at the start of the tenancy 2 years ago, or how much it cost. So delving in very quickly into a little bit more detail. So the tenancy agreement is really the rules of the game, setting out the obligations on the part of the landlord and on the tenant. As I mentioned, it should contain a well-drafted deposit use clause. If it doesn't, you may find that you're not able to make a deduction for the purpose. Very brief example, dispute once, landlord was claiming rent arrears, the deposit use clause merely stated that the deposit was to be used for cleaning and damage, full stop. It did not make any reference to rent arrears or for any other breach in the terms of this tenancy agreement. So whilst rent arrears were owing, and you could see that they were owed, the deposit use clause did not allow the deposit to be used for that. So make sure you've got a really well drafted tenancy agreement and check your deposit use clause. It sets out, or should set out, the liability in the event of breach, and also just consider very carefully whether the tenancy clauses within that tenancy agreement are fair and reasonable. If it does come to an adjudicator is not going to make a determination as to whether a clause is unfair or not. That is up to the courts, but the adjudicator will go on what is reasonable. So just see whether they're punitive in any way, because that is not something that will be probably accepted by the court if it was challenged. And also do remember the Tenant Fees Act, 1st of June 2019. It's not possible for you to claim for checkout fees, for example, anymore. And if you do have a long-standing tenancy and those clauses are in there, then they will become unenforceable as from, I think, the May 2020. So might say that you can claim, but actually you're not able to. So just check and make sure that you're compliant with the Tenant Fees Act as well. This is a poor example of a tenancy agreement. Yes, believe it or not, this was the tenancy agreement. We did go back and ask, could we have the tenancy agreement? And we were told this is it. So it doesn't set out the obligations for the landlord. It doesn't set out the liabilities on the behalf of the tenant in the event of a breach. It doesn't really say what the deposit can be used for. And obviously the tenancy agreements should set out and provide details of the tenancy deposit scheme so that the tenant knows where to go in the event of a dispute at the end of the tenancy. So the check-in report needs to be timely, as close to the start date of the tenancy as possible. So it should be a comprehensive document detailing the condition and standard of cleanliness. It should list all fixtures, fittings and contents along with their condition and any existing damage. So it should note any existing marks, stains, signs of wear and tear. So it's really the baseline record that can be compared at the end of the tenancy, should there be a proposed deduction. Now, photographs can be useful, but they supplement the written word only. A photograph is not going to be able to tell an adjudicator or perhaps a tenant whether a wall is freshly painted or not. You're not going to be able to see that from the photograph. So it's the devil is in the detail of the written word within a check-in report. Check-in reports should be passed on to tenants, to the students. You might have a lead student that's managing on behalf of any other student occupiers, but certainly it should be passed on to them, the date that they move in, and they should be provided with an opportunity to comment on the findings. Usually we find that anywhere between 3 and 7 days within which the tenant actually returns the document with amendments or not is usually the reasonable period. In the event that the tenant doesn't return it, then it might be useful for an audit trail to say that we have not received any comments or discrepancies on the findings of the check-in report, and therefore it is agreed as drafted. Once signed, the benefit of actually getting it signed and returned is that you then actually have an agreed document. And if you've got an agreed document from the start of the tenancy, then it's less likely to result in dispute at the end of the tenancy. Just very quickly, photographs, they can be good. As I said, they can provide a good overview, great for gardens. It can potentially highlight an unusual item, and it can identify specific damage, but it's hard to convey scale or context. You're not able to photograph every aspect of the property, and you would never be able to predict where the damage is going to occur at the end of the tenancy. To make sure that you've got the same photograph of that area at the start of the tenancy, the same angle, the same distance, the same lighting. It's not, this is why they supplement as opposed to an over-reliance on a photographic inventory is not ideal. And as I say, is not able necessarily to clearly show specks of dust or whether or not a wall has been freshly painted. And furthermore, they can also be altered. This is a poor example of a check-in report. There's no author format, it's not dated, it's not signed, there's no detail. It doesn't go to condition and cleanliness. Who made those amendments? Was it the tenants at the start of the tenancy? Was it mid-tenancy, things happening, items moving or being replaced? Or are these end of tenancy checkout comments? So not ideal. This is an inventory from Inventory Hive that you would perhaps be able to use yourselves. And it's really quite an accurate and comprehensive inventory, which would minimise disputes, and the tenant can review it and they can jump on and say, I disagree, and provide a photograph if something's not quite as it's been described. So I think it's really useful to have a really accurate and comprehensive inventory. So changes during a tenancy. Keep a written audit trail. As I said, it's one word against the other. It's no party can rely upon a statement of claim alone. If you're going to give permission to do something, to redecorate, then consider whether those are conditions attached to those permissions, and make sure you've got that in writing also. Also with change of tenants, if a tenant moves out, obviously in student accommodation, potentially there is currently, because of the fixed term tenancies, students will be there for potentially the entire year. They may well move out early, but obviously that's all something that would need to be considered from a business model perspective once the renters rights bill comes in. If one tenant is going and one isn't, then do you need to do a check out and then check them back in? If you're doing a tenant swap, then make sure that you bind the incoming tenant to the original check-in report so that they're happy that the end condition of the property will be based upon the start check-in, even though they weren't perhaps in occupation at that time. If you do have changes of tenants, then make sure that you do all the admin that that goes along with that. And if necessary, you may need to serve prescribed information. So when you get to the end of the tenancy, it's useful to consider doing a pre-move inspection, as I mentioned earlier. That is useful because the tenant may volunteer maintenance issues that you perhaps wouldn't otherwise become aware of until the next student tenants moved in. It can be useful to do that. And also, if you were to potentially suggest that if the garden was left in the state that it was currently at the point of the pre-move out inspection, then it's likely to cost X amount of pounds because you'll need to get it back into the condition it was at the start of the tenancy. Then that may focus minds to try and attempt to do that little bit of cleaning or that gardening. And also it's an opportunity potentially to obtain forwarding addresses, check whether the heating's on or off, confirm utility suppliers, and collect keys as well. So the checkout report itself records the cleanliness at the end of the tenancy, and it should identify what has changed from the start. Do let the tenants know that the checkout is going to take place, and if necessary, allow the tenant to be present, and make sure that any cleaning or repair works is not undertaken before the checkout has been completed. I've seen quite a lot of cases whereby the checkout report actually shows that the property is really clean, professionally cleaned, and there's no damage, and that's because the landlord's gone in and done that work, cleaned it and repaired the property or little bits and pieces before the checkout. And so therefore you've lost that snapshot in time at the end of the tenancy where all of that dirt and damage was available to be recorded. It's really useful if you are doing the inventories yourself, and it's perfectly reasonable and acceptable for you to do that, to take along the check-in report so that you've got a clear reference point, so you can sort of note and run through it side by side, and ensure every aspect of the check-in is covered. Sometimes the shed in the garden is missed off, or somebody's not looked in the shed, and so the check-in report doesn't say what's in there, and at the end of the tenancy you're claiming for a missing lawnmower. Well, there's no evidence that it was there at the start of the tenancy because the check-in report wasn't sufficiently detailed. And also photographs of damage to support the written word is that is when they are useful, but in support of the written word. Make sure you send a copy of the checkout report as soon as possible to the tenants, and also keep a record of sending it. Often we get perhaps parties that say, I've never received it, so this is the first I've heard of any proposed deductions, which is why I've not been able to agree it. You may want to consider using an independent inventory clerk. As I mentioned, you can, as a landlord, do them yourselves. It does sometimes there is perhaps the level of detail is not there, which could impact a claim at the end of the tenancy compared to a professional independent inventory clerk. But nevertheless, there are some, it's perfectly acceptable for you to do them yourselves. And these obviously records hold great significance in a successful end of tenancy claim. Do remember, and I'll touch on this shortly, tenants are not responsible for fair wear and tear, which must be assessed on the length of the tenancy. And if the checkout report records work to be done at the tenant's expense, then we do have a deductions template that you can use to notify the tenants of proposed deductions. And that enables you to do it in a very structured, clear way. And once you've itemised what you want to claim, you should look to return any undisputed balance to the tenants within 10 days, particularly if you're holding the deposit yourself and it's an insured. Going forward on the custodial scheme, then that obviously will be released much earlier. And also there are proposed changes in place for the much quicker release of undisputed deposit monies to tenants in the future. Items left behind. This is one of the photographs that we saw in one of our checkout reports where there's a son, I think, sleeping. To make sure you empty the property of everything. And then moving to that last wheel of the circle, invoices or quotes, helpful to support statements. They can support the age, quality, original cost of the item, and they should be detailed. And any work that you claim should be no more than is necessary to return the property to the same condition or cleanliness. You might want to carry out a little bit of extra work or a little bit of extra sort of improvements, but those should not be charged to the tenants. And if you have things like minimum call-out charges, parking charges, congestion charges, then obviously that detail needs to be advised to the adjudicator or to the tenant, the student tenants, as part of your negotiations, rather than just saying, oh, it's this much. Explain why it might appear to be a little bit higher because of these things. So we do have a product lifespan guide, and this is really, really useful to enable you to try and negotiate these deductions yourself. So it will set out washing machines, dishwashers, ovens, cookers, mattresses, a bit small on the screen there for me to read, but carpets, those sorts of things, as to what is the average lifespan, the product lifespan guide of the items you usually find within a rental property, such as those white goods, perhaps mattresses, beds, but also the usual lifespan of decor as well. And that's really, really useful to really appreciate whether or not you should be claiming from the deposit, because if you've had a 5 or 6 year period of student lets and you haven't redecorated for 5 or 6 years, then the decor is probably at the end of its lifespan and it should be redecorated as part of a maintenance cycle. So consider carefully whether or not those deductions are really useful and fair and reasonable. We do have case studies available also for you under the particular heads of claims. So do have a look at those and see whether there's one similar. No two cases are really ever the same. There might be one tiny little statement that a landlord mentions in their evidence or a tenant admits to that will completely change the decision. But it certainly gives you a sort of a basis upon which the adjudicator will approach the case. And this is exactly how you should be approaching your negotiations with the tenant. So this is how the adjudicator approaches it. So this is, I think, the steps that you could perhaps run through in your own mind to determine whether or not you should be claiming, or whether actually it's not fair or reasonable for you to claim. So the starting point always to remember is that the deposit belongs to the tenant. If you're unable to provide good documentary, robust evidence in support of deductions, then it will always go back to the tenant. So is the party wishing to make a claim on the deposit, the onus is on them to show, to prove the burden of proof is on them to get the deduction from the deposit. Now, the burden, the standard, is on a balance of probabilities. So this is it's not criminal, beyond all reasonable doubt. It is on the balance of probabilities. So these can be quite finely balanced. The adjudicator needs to just be persuaded by one party's evidence more than the other. It doesn't need to be 60, 70, 80, 90%. It's just literally, 51% perhaps. So they can be very finely balanced. We take documents on face value. We are not investigatory. We're more adversary. However, if there is quite clearly something missing, such as a missing tenancy agreement, check-in report, check-out report, and they've been referred to, so the party believes that they've uploaded them on our evidence portal and it's self-managing, then we will reach out and give an opportunity for the parties to send those to us. But you should be using these documents yourself to make a comparison from the start and end of the tenancy as to whether or not you will be making a deduction. And at all times, you do need to consider whether it's fair and reasonable. So the remedies that are available to an adjudicator, and I would perhaps suggest that are proposed to a tenant as part of negotiations, there are only three: making good, which is effectively cleaning or repairing an item, replacing an item, or compensation. So making good is the main go-to remedy, and that is where you should first of all start. Do find that quite a number of parties making a proposed deposit deduction, they jump straight to replacement. So if you can think that replacement will only ever be considered where the item is so severely and extensively damaged that it is beyond economic repair, it costs too much to repair it, you can replace it cheaper than repairing it, or its condition makes it unusable. So there are damages to an item, but it is still usable as that item. So therefore, replacement is not the most appropriate remedy. What you should be looking for is making good, or making good, which is cleaning or repairing. And then if you do clean, let's say there's some stains on a carpet, you've tried to go for the most appropriate remedy, which is making good, you've tried to clean it, but there is a residual stain that remains on the carpet, then you can also claim compensation where an item's, it's shortened its lifespan or is lost in aesthetic value. So those are the only three remedies that are available to adjudicator, and I would suggest that when you're trying to negotiate, you should go for making good. And I think by doing that, then you are more likely to get a resolution. So you're saying to the students, look, the carpet's really, really grubby. I'm not going to claim for replacement because it's already 3 or 4 years old. However, what I'm going to do is I'm going to try and clean it, make attempts to clean it. I'm going to charge you for that clean. And in the event that there's stains left, then I might have to have a little bit of compensation for when I want to renew that carpet in the future, rather than saying, this carpet is absolutely filthy, you're going to pay the full replacement cost, because that is unfair and it goes against the principles of adjudication, which I will come on to. So if you could think like an adjudicator, as part and parcel of your negotiations with the students, then you will hopefully have a better understanding of what's the likely outcome at the end if it were to go to adjudication, and it will provide you with the tools to actually negotiate and settle early on our platform, either via self-resolution, because you've explained it really well and succinctly and properly to the tenant and they fully understand the reasonableness of your claims, or with the assistance of early resolution, whereby one of our team will facilitate that resolution for you. So always think, what does the tenancy agreement say? Does it contain a deposit use clause? Does the deposit use clause enable me to make a deduction from the deposit for my claim? Remember that example I gave earlier didn't make reference to rent arrears. Has there been a breach of a tenancy obligation? Has the tenant actually breached an obligation? If you haven't got a well-drafted tenancy agreement and it doesn't ask them to return the property clean, then you cannot be claiming cleaning at the end of the tenancy. So we're assuming that it's well drafted, that there has been a breach of the obligation. You would then need to be able to just look to see and to show the student tenants, has there been, do I have evidence of what it was like at the start? And if you don't have evidence as to what the condition or the cleanliness was at the start, then your claim is compromised, and you might want to just try and negotiate and get what you can. But if you do, all well and good. You then need to look to see whether you've got evidence of the condition and cleanliness at the end, so that there's a two comparable documents there. So you can say to the tenant, this is the obligation that says you must not cause damage and that you must return it to the same condition. This is the check-in report, which shows that the table was in good condition. It had a couple of ring marks on it, but it certainly didn't have a broken leg or a wobbly leg at the end of the tenancy, which is what the checkout report shows. And then you would need to factor in whether that will happen anyway, fair wear and tear, which I'll come on to, or whether if it's damage. If it's damage, then you will be able to say that there is a change in the condition of this table. It is down to the tenant. There is an obligation not to cause damage, and then you would be satisfied that you've got documentary evidence to support that claim for damage. And then you need to be able to show that you've suffered a financial loss. If you haven't suffered a financial loss, then you're not claiming. You shouldn't be claiming. And then you need to make sure that you're going for the most appropriate remedy. So you want to try and repair that table, so making good that table as opposed to jumping straight to replacement. So you need to make sure that it's fair and reasonable. Have you got an invoice to support that cost of repairing that wobbly leg on the table? And making sure that, as I said, that you are seeking the most appropriate remedy. Fair wear and tear, damage, depreciation, loss, length of tenancy, number, ages, relationships with the tenants, the condition age at the start of the tenancy, reasonable usage, and the average useful lifespan. Do have a look at our document. And remember that you cannot claim any monies that will put you in a better position than you were at the start of the tenancy. So it's effectively making no allowance for fair wear and tear, or seeking to profit from the tenant's deposit, or expecting the tenant to pay for more than the law accepts. So the evidence that you will be showing your tenants are tenancy agreement, any addendums, the check-in report, the checkout report that we've discussed, the inventory, the invoices and receipts, any emails or correspondence that's gone on during the tenancy. Yes, you can dispose of that, or I will give you permission to paint that wall, but you must return it to Magnolia at the start. Rent statements and any third-party reports. I've got a quick case study here. I'm very conscious of time, but I'm very happy to answer any questions. In fact, Ellie, should we go straight to questions if there are any? Because the last are just a couple of case studies. What would you prefer to do?
Yeah, we can do that.
Yep, sure.
We'll do that. Great. So we've got 3 questions. So the first question is, does a clear escape route need to be signed in the property?
I believe it would, yes, but you would need to speak to the fire brigade and things like that on that respect. But I believe you should have clear signage and postage signs on the walls, yes.
Great. The next one is it obligatory for the landlord to provide internet? Students can get a much better deal by organising it themselves.
I suppose that's up for negotiation, really. Most tenancy agreements actually provide for tenants to be responsible for all utilities. Some tenancy agreements actually go so far as to potentially asking them not to change suppliers. But it very much depends on the terms of the tenancy agreement, and if you're happy for them to do that.
Great. And the last one that we've got is, if a student has signed up to T-Life and has a good profile, do you suggest that a landlord carries out a guarantor check as well?
Again, entirely up to the landlord. If they've got they can show affordability, they've got a good reference check, they've got their right to rent. You might still want to go for a guarantor, notwithstanding that. But again, that would be really for you as landlord to decide.
Perfect. And we've actually got one more. The last one is, how many weeks is reasonable for a student tenancy? Is it 47 weeks? ?
it very much depends on sort of business models. I know that if you're in a purpose-built student accommodation, then potentially it ties in with the academic year. Certainly speaking from experience, my daughter in her second year of university, she was in a full 12-month tenancy, notwithstanding the fact that she left April, May, I think it was early as April, but still had to pay rent until June. But obviously all of that is going to potentially change with the Renters' Rights Bill that comes in, where there are no fixed term tenancies, and everyone will automatically convert to periodic tenancies, where 2 months' notice can be given by the parties, which may interfere somewhat with a landlord's sort of business model, but it's not yet in force. We don't know whether there's going to be any tweaks on that front. But I have done a useful piece with the NRLA. So if any of you are members of the NRLA, then do have a look at their website on tips on student accommodation, and we will be keeping people updated on the outcome of the Renters' Rights Bill as and when it passes royal assent. And we will be providing update webinars and things on that in due course.
Perfect. So that's it. No more questions. Just double checking. Yeah, that's all of them. So thank you very much, everyone. Thank you, Sandy. And we'll leave it there and enjoy the rest of your day, everyone.
Thank you very much. Thanks. Bye-bye.
Bye.